law, but
so
you have a great
let me understand.
No fines, no penalties.
May I ask you a question?
Questions on there? There's the address.
Yeah,
there's
no, I
the,
have a question. Can you get your supervisor here, please? Is the stop over?
The stop is over. You may leave.
All right.
I don't exit until I get out. Until I leave.
Well, you said the stop is over, right?
Don't get out, bro.
Okay, I'm not getting out. I will.
Open the door. Let me get back in my car.
Okay, there is no need to draw your weapon, man. Are you drawing your weapon?
Get out of the car.
I didn't get out of the car. You told me that already. Yeah. Did I get out of the car? Go f yourself. Yeah, right over there you can.
Official reprisal for protected speech offends the Constitution. That sentence comes from the United States Supreme Court itself in the case of Hartman versus Moore. Not a protest chant, not an opinion column, a binding legal principle. Hold on to that sentence, because everything that follows happened in its shadow. Picture one word, a single shouted word out of a moving car window on a quiet street in Seabrook, Texas. That word triggers a U-turn. It triggers flashing lights. It triggers a hand moving toward a holstered gun. One word becomes the spark. What you're about to see is what happens when a badge answers speech with force.
Brought to us by Clear Lake Community Watch's channel. Be sure to check out the description below and give them the credit that they deserve. On July 20th, 2022, Auditor Clear Lake Community Watch, who we will refer to as Mr. Clear Lake, drove past Deputy C. Vega of the Harris County Sheriff's Office as he was conducting a traffic stop in Seabrook, Texas. Mr. Clear Lake rolled down his window and yelled an anti-police sentiment, including a profanity at Deputy Vega as he drove by. Deputy Vega abandoned the traffic stop, got in his vehicle, made a U-turn, and began to follow Mr. Clear Lake. Mr. Clear Lake properly signaled and made a right turn, and Deputy Vega activated his lights to pull him over. Mr. Clear Lake immediately pulled into a gas station and stopped his vehicle.
Roll it down?
Why do you pull me over?
I'll tell you that if you roll it down.
Why can't you tell me now?
Because the reason I pulled you over is you were yelling something from your car.
So what?
Huh?
So what? That's why you pull me over, because I'm
Because I
yelling?
don't know if you're in need of help or anything.
Oh, I don't need help.
So,
Thank you.
Okay, let me see your driver's license real quick.
I don't need help.
Before we go deeper into what the body cam and dash cam actually show, make sure you're subscribed to Police Misconduct Case, because we don't just cover the story, we follow the evidence. Here is the record. On July 20, 2022, a man affiliated with a channel called Clear Lake Community Watch, we will call him the Auditor, drove past Deputy C. Vega of the Harris County Sheriff's Office. Vega was working a traffic stop. As the Auditor passed, he shouted an anti-police comment out the window, including a profanity. That's it. That's the entire offense. Vega abandoned the stop he was working, got in his car, made a U-turn, and went after him.
2006 case of Hartman versus Moore, the Supreme Court stated that, quote, official reprisal for protected speech offends the Constitution because it threatens to inhibit exercise of the protected right. And the law is settled that, as a general matter, the First Amendment prohibits government officials from subjecting an individual to retaliatory actions, including criminal prosecutions for speaking out. As the Fifth Circuit Court of Appeals, which has jurisdiction over Texas, explained in the 2002 case of Keenan versus Tejeda, to establish a First Amendment retaliation claim, a plaintiff must show that, quote, they were engaged in constitutionally protected activity, the defendant's actions caused them to suffer an injury that would chill a person of ordinary firmness from continuing to engage in that activity, and the defendant's adverse actions were substantially motivated against the plaintiff's exercise of constitutionally protected conduct. Here, it is nearly indisputable that Mr. Clearlake was engaged in protected activity, as the Supreme Court has long held that profanity is protected speech under the First Amendment. And Deputy Vega admitted that he pulled over Mr. Clearlake because he yelled out the window. However, it is less clear whether a court would determine that being subjected to a traffic stop that resulted in a warning and no citation or arrest would constitute, quote, an injury that would chill a person of ordinary firmness from continuing to engage in that activity.
Here is the irony. Vega would later claim he pulled the man over because he was concerned about his well-being. Not because he was offended, just concerned. But under the law, motive is everything. The First Amendment doesn't protect speech only when the government approves of it. It protects speech that is loud, rude, and profane. The Supreme Court has long held that profanity itself is protected expression.
However, the court also recognized that, quote, some retaliatory actions, even if they actually have the effect of chilling the plaintiff's speech, are too trivial or minor to be actionable as a violation of the First Amendment. For instance, in the 2009 case of Benson versus McKinney, the U.S. District Court in the Western District of Louisiana, which is part of the Fifth Circuit, held that a traffic stop resulting in a citation for which there was probable cause was not a sufficient injury for a First Amendment retaliation claim when the plaintiff did not allege that the ticketing officer threatened him, or that the traffic stop was otherwise effectuated in an intimidating manner. Based on this decision, the Western District of Louisiana noted in the 2012 case of Simmons versus City of Mamou that, quote, not all instances of detention by police would chill a person of ordinary firmness from continuing to engage in protected activity.
The Fifth Circuit, which governs Texas, set the test in Keenan versus Tejeda. Was the person engaged in protected activity? Did the officer's action cause an injury that would silence an ordinary person? And was the officer's action motivated by that protected speech? Two of the three elements are barely in dispute here. The third is where it gets complicated. In Benson versus McKinney, a federal court ruled that a routine stop with a citation wasn't a serious enough injury to sue over. But this stop was not routine. This stop ended with a hand on a gun. Retaliation wearing the mask of concern. That is the first time you'll hear that phrase, and it won't be the last. Now watch what happens next, because the footage does something the report can't. The deputy asks for ID. The auditor, who is legally carrying a holstered handgun, hands over his driver's license and his license to carry. Exactly what Texas law requires under Section 411.205 of the Government Code. He says nothing else. He doesn't have to.
Okay, you guys your driver's license?
What for?
Can you use the turn signal when you make a turn?
Of course I did.
Let me see your driver's license.
You can hear the sound on the dash cam too.
Let me see your driver's license. You can just crack your window if that's what you want to do.
It's already cracked.
I can't see that.
Well,
This thing.
it doesn't matter. Here. I don't wish to answer questions.
You have to let me know if there's a weapon in the car. Did you not take the class?
I did.
Did they tell you you have to tell them?
When you demand identification, I have to display this. That's what they told me in the class. That's what the law says.
The officer wants to take a weapon.
And actually, if I don't display, there's really not much you can do because there is no penalty attached to that. I have to carry this if I'm carrying this.
Are you carrying?
I don't answer questions.
Okay, so if you have a weapon in the car, then what?
You got one on your hip. So what?
The statute does not require him to answer questions about the gun. He complied with the letter of the law completely. Then he asks the deputy a simple question. What is your name? The deputy doesn't answer. He points at his own badge and makes a mocking comment about the man's English. A sheriff's department policy actually requires deputies to identify themselves to the public. The deputy ignored his own department's rule in the same breath he was enforcing the law on someone else. Here's the moment that turns this from a legal footnote into something that should worry you. The deputy tells the man the stop is over.
Under Section 46.02 of the Texas Penal Code, quote, a person commits an offense if the person intentionally, knowingly, or recklessly carries on or about his or her person a handgun in a motor vehicle that is owned by the person or under the person's control at any time in which the handgun is in plain view, unless the person is 21 years of age or older or is licensed to carry a handgun, and the handgun is carried in a holster. As of September 1st, 2021, Texas citizens who are not disqualified from carrying a handgun in a public place can do so without a license to carry, also known as an LTC. However, individuals who obtain a handgun license are subject to additional requirements when it comes to interactions with the police. Under Section 411.205 of the Texas Government Code, quote, if a license holder is carrying a handgun on or about the license holder's person when a peace officer demands that the license holder display identification, the license holder shall display both the license holder's driver's license and the license holder's handgun license.
Do I smell alcohol in your breath?
No, you don't.
How do I know?
Because you can't smell my
I
breath?
can smell something coming
Oh,
out.
really?
Let's see. Let me do some field sobriety on
I
you.
don't think so.
Okay. Yeah, where are you coming from?
Huh?
Where are you coming from?
You saw me where I was coming
No, I
from.
just saw you driving down.
Are you done with this?
I'm done with that, yeah.
All right, cool.
Where are you coming from?
I don't answer questions. I've already told you. Let me know when I'm free to go. Also, what is your name? Your name? Sheriff? That's your name? Sheriff?
Right above it, right there. You see
I'm not familiar with the English alphabet, sir.
it? Be on the ticket.
Okay. Can I have an incident number, please? Oh, a ticket. A ticket, okay. You can do because there is no penalty attached to that. I have to carry this if I'm carrying this.
Are you carrying?
I don't answer questions.
Okay, so if you have a weapon in the car, then what?
You got one on your hip. So what?
He says, you may leave. Then, when the man opens his car door, not to run, not to reach for anything, simply to exit, as he'd just been told he was free to do, the deputy draws his weapon. Ask yourself this: what does it take in America today to have a firearm pointed at you for opening your own car door? Department policy allows an officer to ready a weapon when danger is anticipated.
Policy 302 of the Harris County Sheriff Department Handbook, which outlines the department's requirements for so-called professional conduct by deputies and other HCSO employees, creates a so-called duty to provide official identification. The policy states that, quote, all employees shall present their HCSO identification card when requested by a member of the public, when engaged in law enforcement activities, or when in uniform. Although Mr. Clearlake did not request Deputy Vega's identification card, he did ask for his name, and Deputy Vega's rude and mocking response certainly didn't comply with the spirit of this policy.
It does not allow a weapon to be displayed in a threatening manner unless deadly force could reasonably be justified. A man opening a car door he was told he could leave through is not that threshold. A badge is not a shield against the Constitution. That is the second time you've heard that phrase. And it is the exact principle at stake when a public servant uses his authority to punish speech he didn't like.
Law.
Do me a favor, while I have you here, okay? I don't want you exiting the vehicle because you have a weapon in the car.
Did I exit the vehicle? Did I exit the vehicle?
Give you a heads up.
Did I exit the vehicle? Hey, can I? You do have a dashcam, right? Very good. You can't just pull me over because I said the police. I hope you realize that, stupid. I'm sorry?
You have insurance on the vehicle?
Yeah.
Can you show it to me, please? It doesn't come back.
Of course it comes back.
Not on my system, it doesn't. Also, it's not typical behavior for somebody to be yelling out of the vehicle. Have you had anything to drink tonight? Is that your current address, 1622?
Is that a question?
Yes, sir. Is that your current address?
Do I answer questions?
Okay, I'll just assume that's incorrect then.
And why would you do that?
I'm asking you a simple question.
Did you read my address on the driver
It
license?
didn't have an address. It didn't have an apartment number on your driver's
Of course it
license.
does.
Let me see. Can you verify?
You've already seen it. I've already complied with that part.
I know. Okay, I'll be right back. Yeah, I say that I've never met anybody quite like you that would yell at an officer doing their job. But
So,
you have a great
let
day.
me
There's no
understand.
warnings, no fines, no penalties.
May I ask you a question?
There's questions on there. There's the address.
Yeah,
There's
no, I
the-
have a
and
question.
there's an incident
Can you
number
get your
on the thing right
supervisor
there.
here, please?
No,
Is the stop over?
the stop is over. You may leave.
All right.
Please don't exit until I get out. Until I leave.
Well, you said the stop is over, right?
Don't get out, bro. I have to-
Okay, I'm not getting out. I will.
Open the door. Let me get back in my car.
Okay, there is no need to draw your weapon, man. Are you drawing your weapon?
Get out of the car.
I didn't get out of the car. You told me that already.
Get to it right now.
Yeah. Did I get out of the car? Go yourself. Yeah, right over there you can.
After the stop, the auditor filed a public records request for the footage. The sheriff's office called it vague and overly broad and mailed its response to the wrong email address. He never got the footage through that channel. He says he intends to file a complaint and a lawsuit.
According to Policy 505 of the Harris County Sheriff Department Handbook on the Use and Discharge of Firearms, quote, "The deputy's unsnapping of the holster and placing a hand on the service weapon is permitted when approaching a possibly dangerous situation." And, quote, "Firearms may be removed from the holster and readied for use in situations where it is anticipated they may be required." However, the policy also states that, quote, "Firearms shall not be displayed or pointed in a threatening or intimidating fashion unless it is objectively reasonable to believe deadly force is justified, or there is a substantial risk that the situation may escalate to the point where deadly force would be justified. Firearms shall be secured and returned to their holsters as soon as practical when it is determined that deadly force will not be necessary." Another section of the policy requires deputies to, quote, "exhaust all reasonable means of apprehension and control before resorting to the use of a firearm."
If he does, the case will likely turn not on the retaliation claim, which courts have historically been reluctant to fully recognize for a stop this short, but on a Fourth Amendment claim that the deputy had no reasonable suspicion to pull him over in the first place. A badge is not a shield against the Constitution. Say it a third time, because by now, the pattern should be undeniable. One man exercised a right the Supreme Court has protected for decades. The response was a chase, a stop without cause, and a drawn
Or
weapon.
even that there was a substantial risk that the situation could escalate to that point when Mr. Clearlake simply opened the door to his vehicle.
A warning? A warning? For what? Failed to signal with turn indicator within 100 feet. Drew the weapon on me. He drew the gun.
We want you to look at this yourself. Search Hartman v. Moore Supreme Court Opinion. It's public, it's free, and it's 2 pages that will change how you watch every police encounter after this one. Then tell us in the comments, should a raised voice ever be enough to draw a gun? If this investigation opened your eyes, hit like, share it with someone who needs to see it, subscribe to Police Misconduct Case, and turn on notifications. Because we don't stop digging until the record speaks for itself.
Mr. Clearlake was not aware of this request until he went to the department in person in an attempt to obtain the documents. As of the date of writing this episode, Mr. Clearlake has not indicated that he has received any materials from the public records request. Mr. Clearlake has also indicated that he intends to file a complaint and a lawsuit. Overall, Deputy Vega gets an F for retaliating against Mr. Clearlake for exercising his First Amendment rights, initiating a traffic stop against him without reasonable suspicion, and unnecessarily brandishing his firearm. It is clear throughout the encounter that Deputy Vega was angry with Mr. Clearlake for the sentiment he shouted from his window, and mentions his speech several different times throughout the encounter. During the entire interaction, Deputy Vega seems to be looking for any excuse to take further action against Mr. Clearlake, and he goes on several fishing expeditions in an obvious attempt to obtain reasonable suspicion to search the vehicle or find some other justification to detain Mr. Clearlake for a longer time or arrest him. This traffic stop demonstrates why it is essential that police officers respect the First Amendment and refrain from allowing their egos to dictate their decision-making. Mr. Clearlake gets an A for refusing to answer any of Deputy Vega's questions, complying with the law while declining to provide any more information than was required, and for taking appropriate action after the traffic stop. Although he used aggressive language towards Deputy Vega, he was completely within his First Amendment rights to do so. And Mr. Clearlake demonstrated throughout the interaction that he was well versed in both his constitutional rights and his legal obligations as an LTC holder. I commend Mr. Clearlake for filing a public records request, following through when the records were not provided, and pursuing a complaint and a lawsuit against Deputy Vega. And it will be interesting to see how his case fares in court.